their evening to learn a little bit about landlord-tenant law. We should thank Flingers and Kelly's Bakery who provided the food tonight. Thank you so much. And also the Action Research Center for supporting this. So I am the managing attorney at Prairie State Legal Services. We have an office here in Bloomington, and we have 3 attorneys, and I'm going to tell you a little bit about Prairie State before we start so you can understand sort of the angle I'm coming at this at. So Prairie State provides free legal services to people who don't have enough money for an attorney or who are over 60. I gotta wake this mouse up here. It's gonna wake up and then it's gonna advance like 10 slides. All right, there we go. Let's see here. Okay, this should work. There we go. All right. So Prairie State's celebrating its 40th anniversary this year. We serve 36 counties. This is our service area here in Bloomington. Our office is in downtown Bloomington, just on the other side of the courthouse. So I don't know how many of you have had contact with the court system, but representation by an attorney is really important. It's hard. Being in court is tough. There's almost a different language that's spoken by attorneys and judges, so knowing what's important and what's important to talk about really does affect whether you're going to win or lose in a court case. And without a lawyer or without being able to learn what you need to talk about, you could have a great case and lose, or you could have a terrible case and win. So it is important for fairness for a lawyer to be involved. So just so you guys have a basis, for Prairie State services, you have to meet certain income levels or be over 60. And for our services, to give you an example, for a family of 4, it'd be about an annual income of $30,750. So I'm just going to give you an idea. I'm lucky today in that I'm talking about something I actually know about in front of you guys. I get asked to talk a lot about different legal areas, and some of them are things I do once a year, and so it's a little bit harder than landlord-tenant law, which is something that I deal with on a regular basis and have done for the last 14 years. So this is an area that you can see for Prairie State. For our office, the Bloomington office, like I said, we have 3 attorneys. We had 381 housing cases last year. We also deal with a lot of family cases. Those are usually domestic violence cases, Medicare, Medicaid, SSI, and other public benefits, and then some other types of cases. Okay, so I'm going to get into the meat of the discussion here today, the reason you guys all came. I'd like you to know that you can feel free to ask questions on the fly. We have a small enough group that we might be able to do that. If we get too off topic, I'll bring us back on topic. So, landlord-tenant relationships. It's really important that you try and start off the relationship correctly. And I wrote down some tips in the PowerPoint that are good, just good practices that you should try and incorporate in your rentals. So, you want to make sure that that you read the lease. It's a basic that I say that, but I'm pretty sure in my undergrad career and while I was in law school, I never sat down and read the lease. So you should do that, really. It's worth your time. When you pay the landlord, you want to make sure you understand what you're paying for. Is it, if you're applying for housing, this is an application fee. Okay, why am I paying an application fee? And the landlord will tell you it's for the credit check or some sort of expense that they have to incur. We've seen situations where people pay a security deposit and then they're told afterwards that pay a security deposit to see an apartment. Basically, you have to pay the security deposit before we'll even show you an apartment, but you'll get it back afterwards. And then they don't get it back afterwards, and that becomes contested. So you want to make sure when you're making payments that you understand what it's for, that you agree what it's for, and potentially that those payments are recorded by receipts or in writing. You want to consider whether you can afford the rent. I think that's something that people sort of overlook sometimes. You know, sitting down and coming up with a budget, can I afford $1,000 a month in rent? Is that something that I can fit into my budget or not? You want to get receipts for every time you pay rent, and you want to keep those receipts, or if you pay by check, you have to cancel a check. But you may need to prove the rent you paid 4 years ago. And so if you don't keep the receipts that you have, or your canceled checks, or your bank statements, something to show the payment of the rent, you might be in trouble if you ever have to prove it was paid. If you're living with roommates, and this is especially true of college students, you want to know and trust the people you're living with, because you're on the hook for their actions, whether that's destroying the apartment or not paying their share of the rent. If you sign a lease where all 4 people are on the lease, let's say it's 4 roommates, and 1 roommate stops paying the rent, the other 3 roommates have to pay that rent, or they will all be evicted and a judgment will be issued against all of them. So you want to make sure that you know and trust your roommates. Now, I know there are some other types of situations where the landlord sort of fills a 4-bedroom and it's like 4 separate rooms with a common area. That's a little bit different. I'm talking about where everyone's on the same lease. So you want to know your landlord's name, their business, a name, their home phone numbers, their business phone numbers, and their business address. And you would be amazed, and maybe some of you won't be, some people don't even know their landlord's last name. They come into me because they have a dispute with their landlord, and I say, okay, what's your landlord's name? They have no idea. They could not tell me, even though they've rented from the guy for months. That's usually a red flag if the landlord won't tell you their last name or give you ways to contact them. So you would want to know those things, and if you can't find them out, it's probably showing you that you're going to have a problem in the future. If there's a manager, you want to know their information in case something breaks. If that's what they're charged with, and the pipe breaks or you get locked out of your apartment, you're going to want to be able to contact someone at that time. So here's another sort of basic thing, but it really needs a lot of attention because, again, people overlook this. And you need to read your lease, understand what it says, and you can negotiate changes in your lease. If you talk about changes, and I've seen this as well, where people talk about the changes and the landlord and the tenant agree, okay, we're not going to abide by this term in the lease, you've got to cross it out on the final lease, otherwise you may be held to it if you sign a document where that provision is not struck from the lease. You want to know the amount of rent, when it's due, where to pay it, and how to pay it. That should be very clear. The utilities is also an issue that you want to nail down. Who pays the water? Who pays the electricity? Who pays the gas? There needs to be a clear agreement on that. It's good if it's in the written lease. You want to make sure the lease reflects any oral promises you make. If the lease says no dogs, and the landlord says, yes, you can have a dog, you want to cross out the thing that says no dogs, and you want to say explicitly, tenant can have 1 dog or something, whatever the agreement is. Again, if they're not in the lease, they're not binding. At the end of the day, the judge will say, look, I got this document with both of your signatures on it. We're going to go by what the document says. You want to understand all additional costs or fees. There's a lot of fees built into these leases, especially the student housing leases. So you want to sit down and understand what those are, because once they start getting triggered, people find themselves owing $2,000 or $3,000 more than they thought. So oral leases are when there's no written lease. So, I've had both written and oral leases as a tenant, and they both have their benefits and negatives. So an oral lease is always a month-to-month lease if you pay your rent monthly. And so what that means is, if you don't have a written lease and you and your landlord for some reason don't get along, or your landlord decides he wants to sell the building, or you want to move because you found a new situation, all you have to do is give 30 days notice to move out, or the landlord has to give you a 30-day notice to tell you to move out. Again, I talked about it before. Just understand, if you're signing a lease that says the rent is $1,500 a month and you have 3 roommates, you're on the hook for $1,500 a month, even if you agree to split it 4 ways. And it's really, really important. We see that on a weekly basis, that people just never understood that going in. So when you move into your apartment, it's good to take photos of issues that you notice. Broken windows, broken blinds, holes in the wall, stains on the carpet, dirty fridge, dirty stove. When you move out, the landlord is likely going to hold you responsible for damage to the unit. And we run in, and I'll talk about it a little bit more later, but people say, well, it was like that when I moved in. If you don't have a photo or some documentation where you told the landlord, hey, there's a torn carpet here, then you're probably out of luck. Renter's insurance is a really good idea because it's just simply so cheap. It's dirt cheap. It's like $15 a month, or I haven't bought renter's insurance for a little while. No, I did. I had it 3 years ago, and I'm pretty sure it was like less than $20 a month, and I had a lot of stuff. I had a house full of stuff. So for apartments, renter's insurance is cheap, and it covers your lost property. If the ceiling caves in because the roof was leaking and it destroys your property, you'll be able to file a claim for renter's insurance, or if your stuff gets stolen, or if there's a fire or something like that. If you don't have renter's insurance, the landlord's not required to reimburse you unless he was negligent, and that's tough to prove. I'm going to talk a little bit about the landlord's responsibilities and the landlord's responsibilities when it comes to landlord-tenant situations. So keep in mind, I've practiced for 14 years. For 11 of those years, I've represented tenants, and for 3 of those years, I represented landlords. So I do come at it from a tenant-friendly position. The landlord can't just change your locks. If the landlord gets angry at you, he can't just change your locks and say you're out. You come home one day and your lock doesn't work, and the landlord says, I've evicted you, I've changed your locks. That's not allowed. They can't tamper with, turn off your utilities, so you have a dispute. The landlord can't shut off your gas so that you have no heat and hot water. That's not allowed. The landlord must pay for the utilities in common areas. If you're in a 2-unit building and the hallways are common, the landlord's supposed to pay for those, the electric to those parts of the building. It shouldn't be yours if it's a common area. The landlord shouldn't enter your home unannounced. You can't be in bed and the landlord just walks into your building and unlocks the door and comes and does whatever they're going to do. They should give you some notice. If there's an emergency, a broken pipe or something like that, then they can come and try and remedy the situation. And landlords can't discriminate against tenants due to race, color, religion, national origin, familial status, sex, or disabilities. So that is illegal. this is a big one that we see, especially in Bloomington, more so than normal, and in the rural parts of McLean County in our service area. Landlord must provide safe and habitable housing. So what that means is working heat, the water should work, the sewer should work. You shouldn't be dealing with leaks every time it rains, and you shouldn't move into a place with bed bugs and cockroaches and pests like that. The landlord's required to comply with the city housing code if there is one, and there is one in Bloomington and Normal. And the landlord must make repairs in a reasonable time. And there really shouldn't be any unreasonable fees or fees that aren't in the lease. So the landlord can't say, well, you missed paying rent, so I'm going to charge you a $1,000 late fee or $300 late fee. That's an unreasonable charge. So what do you do in the common situation that we see? It's more common than it should be with you're living in a house and basically the heat's never worked properly. You should contact the city of Bloomington or Town of Normal Code Enforcement. They both have enforcement arms. They'll come out, they'll see what's going on, and if the place isn't up to code, they will require that the landlord fix that problem. If the landlord doesn't cooperate with them, they know to make a referral to us, and people are always welcome to call Prairie State if you qualify, or you can seek representation by a private attorney if you don't qualify. Okay, so what's the tenant supposed to do? The tenant's supposed to pay their rent. That's probably the most basic thing, and the main reason that we see people getting evicted is people just aren't paying their rent, and they're not paying their rent on time. So ideally, from the landlord's perspective, from what I've seen, you make your rent payment on the first of the month or very close to it within usually a 5-day window in full. So if your rent's $700 a month, you pay $700 a month on or around the first of the month. We see a lot of tenants paying $100 here, $300 there, $200 there, and that's aggravating to the landlord for one. And two, it's easy to fall behind, and it's hard to keep track of how much you owe, especially if you're starting to pay late and you're incurring late fees and things like that. So just pay your rent on time if you're a tenant. That's probably the most basic responsibility, and if you're having problems with that, it will make you an undesirable renter to all landlords. Illinois law doesn't allow withholding rent. You can't withhold your rent, no matter how angry you get at your landlord, no matter if you've got sewage backed up in your apartment. You have legal rights of what you're able to do, but one of them is not paying your rent. You require, the leases usually require, and just sort of basic responsibilities require that if you're responsible for the utilities, you keep them on. A landlord can't have a building where in the winter the heat's off and the pipes could freeze. That's just going to be a problem. You really should be able to keep your rent paid, keep your utilities on. You want to work with the landlord. It's an ongoing relationship that you have with the landlord, and it is like a relationship, like a employer-employee, teacher-student, boyfriend-girlfriend. You got to work together on a lot of things, and it's much better if you have a working relationship than if you're enemies. You shouldn't disturb other tenants or neighbors. Now, they're a lot more flexible in student housing. I hardly ever see an eviction in student housing for having too many parties or anything, but it's possible. But you do see it a lot with regular housing where people have kids and there's a problem neighbor who's throwing parties till all hours of the night. You're not allowed to commit crimes in the apartment. You don't want to allow guests over who will disturb others or commit crimes. And you're responsible for your guests. So if you invite someone over and they get into a fight, you could be evicted for that. So I should ask, do you guys have any questions? I encouraged you to interrupt me if you wanted.
I've got a few.
we're gonna be in a question and answer. Do you have any that we've dealt with?
Yes.
Okay.
First question, and I'll be upfront. I'm a landlord. I just came from, and I think this is all very fair. Actually, I'm surprised that I'm not going to get beaten up as much as others. Good technical ones. You said that I certainly agree with you that charging people money to come and see in apartments is just terrible. But we do have to pay for a background check, which costs us money. Now, I always say to the tenant or the prospective tenant, please be honest with me. If you've got something that I'm not going to like the sound of,
right.
I don't want to take this $50 off you and then tell you I'm not going to rent from you. But and I've had this happen, where they've sworn blind they didn't have anything bad on their record, and it's turned out they've got some pretty awful things on their record, and I've refused to give them their money back for the background check because it's cost me that money.
Right.
Is that legal?
I think that's fine.
Yeah.
You know, a lot of landlords charge what they call an application fee. As long as it's clear what it's for, as long as, you know, if you're getting charged $20 and you're charging them $200, that's not fair.
No, of course
but,
not. No.
Right.
No.
So.
They're signed to say that they understand that too.
Yeah, that's great.
Next question. I'm sorry if I'm hogging the floor tonight.
No, it's okay. To break it up, it feels like I'm lecturing everyone.
Are you able to afford, you said the tenant should decide, are they able to afford the rent? Am I, once I've done the background check, legally entitled to make that call?
Yeah.
No.
You can make a decision, just you can't discriminate against them for the reasons that I said, and
Sure.
financial
Well, we
ability
wouldn't
to
do
pay
that.
is not one of those.
About negotiating to have the lease changed, that's before everybody signs off on it, correct?
Correct.
Yeah. And if...
Oh, should I be repeating these questions? Can you guys hear them? Okay.
Yeah. And the last one is, if a tenant does decide not to pay the utilities, and as a consequence of that, property damage occurs, like a frozen pipe, and particularly if it causes water to cascade down into the apartment below, where some other poor sucker is living, can I sue them for that damage?
Sure.
Right. That's it, I finished.
All right. Good questions.
Okay.
It's good to break it up.
I was just gonna ask something. Can the landlord have an additional fee for paying your rent online? I know that was a question that I've been asked.
Yeah, if it's in the lease, they certainly can, you know. Some people, I'm guessing that's because the credit card company charges the landlord a percentage to do that, and so that's why that fee's in there. But if it's agreed upon, then yes. If it's not agreed upon and the lease says you can pay online and it doesn't talk anything about a fee, then it's arguable and you probably shouldn't be charged that fee.
We have a problem with smoking, and we have one house that is completely yellow, and we refuse smokers from now on.
So the question is, can a landlord refuse to rent to smokers? And I believe you can. I mean, like I said to the gentleman here, there's just a limited number of reasons of things you cannot hold against tenants, okay? So their race, color, religion, national origin, familial status, sex, or disability. Now, if you're not doing one of those things, you can refuse to them for every other reason out there.
And then
They can't afford to pay it, in my opinion. Your criminal background is too nasty, in my opinion. I didn't like the way you talked to me. You know, you can refuse it. So, hopefully that answers
okay.
that.
The other thing you might want to add is mold. My granddaughter got stuck in a place that had mold. She couldn't use the bedroom at all. And it was there for a year, and she finally was able to get out of there.
Yeah, mold's a little bit complicated. We'll talk about that a little bit later. I don't want to get too far off topic. Yeah.
Can you just define familial status? That includes children, right? Like you
Yes.
can't deny someone for having children.
Correct.
Okay.
So, you know, I think probably a good example, which sort of bucks, and a family with 2 adults, 2 boys, and a girl applies for it. The landlord cannot say you have too many kids, we can't put you in this apartment. That actually would be discrimination due to familial status. And again, that's one where I'm telling you it's gonna,
We've been in a situation where we've had small apartments where people have come along, and then we get into this conflict with family services because there's a surface area plus there's age of children who aren't of the same gender sharing the same room. You then seem to get a conflict in the law.
yeah, it's not really a conflict in the law. It's an issue. HUD has some guidelines, and so if you're getting Section 8 money, then you cannot rent to them, and HUD will catch that. They'll work out, is this a two-bedroom apartment? You know, DCFS, I'm not going to speak, I'm guessing that's who you're
Yeah.
talking about. DCFS, I'm not going to speak for them, but really, the landlord's not there to make that call. That's between the client and DCFS. And, you know, you could get yourself in trouble if you're trying to tell the client, hey, you might get in trouble with DCFS, so I'm not going to rent you this apartment because you have too many kids.
I think in that situation I would be calling the DCFS myself and finding out what they're going to say. And then if they say it's okay, then I'll have to rent.
Yeah, well, DCFS doesn't control this, okay? This, you are talking about a conflict in the law. You know, most people don't have anything to do with DCFS. If DCFS is involved, it's usually not because there's too many boys or girls in a bedroom or something like that. They're involved because there's been some bad actions.
Yeah.
Well, when the children are in foster care, they have to have their own rooms.
Yeah, again, that's sort of between DCFS and the parent. And if you guys get into it, you're opening yourself up to a discrimination lawsuit.
We are living in a small apartment, so we are in the lease, oral lease is month on month. Do we have a document with the landlord?
You don't have to. There's oral leases that aren't written. And so, am I understanding you correctly that you don't have a written lease?
Yeah.
Okay, that's a common scenario, and what it means is that all the agreements have been made verbally, and the landlord still has to follow the basic law of what they need to do, which is keep the place inhabitable. They can't just lock you out or shut off your gas, but you know, there's no written lease.
So do we need to ask the landlord, we need the written document?
You-
We are in the oral month on month basis.
You can ask the landlord for a written document. You don't have to. The landlord doesn't have to agree to give you one. But if you want a one-year lease, written lease from the landlord, you can ask him for one and he can make a decision yes or no. There's no requirement that everyone have a written lease. Lots of people have oral leases. It's up to you to negotiate if you want a written lease to get that.
No, I'll ask you personally later.
Okay. Depends what the lease says. If you got an oral lease like this young woman over here, you can have whoever you want moved in. That's one of the protections of having a written lease. It'll say only these people are allowed to live there, or only, you know, 2 adults and 3 children. So you have to read your lease and see what it says about adding occupants. All right, these are great questions. I want to move on, unless this has something to do with that.
If students are renting apartment means, what are the things we need to consider at first? Because we came from out of the country, so we don't need the legal things we need to see in the written lease.
I'm not sure I understand the question.
If students are renting an apartment means, what are the things we need to consider?
I think that's a little bit too broad of a question. I'm going to stick to the slides and I'll come back to it if we have time.
It changed when you had mobile homes.
All right, mobile homes. So I'm going to inject a little bit of personal opinion into this. I personally cringe when I see people approaching us with mobile home issues. You know, some mobile home situations are going to be fine, but we probably see the worst ones, and they're always, there's a lot of fraud and pitfalls. People buying mobile homes, either getting them for free or buying them for like a few $100 and they're uninhabitable. And the person has to fix them up, get them up to code, and if they don't, they'll start getting fined by the city, and these folks usually aren't capable of doing that. So we see, you know, we've seen ones where raccoons were living in the attic, none of the pipes worked, the heat didn't work, the floor's falling in. You know, we see, it seems like mobile homes have more problems than apartments, and they're harder to deal with from a legal perspective and for the tenants if there is a problem. There's also a lot of rules. Usually if you sign up for a mobile home park, the rule book is literally this thick, and it's got tons of different provisions. And you just need to make sure that you understand those provisions and you follow them. And if you don't, you'll get a notice. And if you don't resolve it, you'll get evicted. And if you own the mobile home, if you own a $10,000 mobile home and you're evicted from it, then you have to sell it or you have to try and move it, which is usually, you know, not worth the money. So you're selling and you've got crunch time, and so it can be a tough situation. I'm sure there are good situations, but I don't get to see those. I only get to see when it falls apart. Okay, so security deposits. This is a big area of concern. A lot of people have complaints or disputes when they don't receive their security deposit back, or they don't receive the full amount of their security deposit back. So this is sort of a list of what you should do to protect yourself. And then you will be able to substantiate a position that you didn't damage the place or leave it in any worse condition than you found it, minus normal wear and tear. So you want to take photos when you move in. You know, in this day and age where everyone's got a high-end camera in their pocket, you might as well just take a bunch of photos and let them sit on your hard drive for a year. Complete a move-in, move-out checklist. We have a publication on our website called the Renter's Handbook. That's got an appendix, and one of the things is a move-in, move-out checklist. It is excellent. It goes through everything. If you see a broken window or a torn screen, you can mark it on there and submit that to the landlord. I think it's got a place for a signature from the landlord, and then at least you're on the same page. You're going to take photos when you move out. Even if you don't think you've got any problem, you may learn about it 2 months later when the landlord doesn't return your security deposit. So you want to take photos when you move out. Ideally, you'll do a walkthrough with the landlord so that they can point out, you know, issues. You don't want to be combative about it. You do want it to be a conversation, both of you, about, you know, about pointing out problems. Clean the place thoroughly. People don't clean their fridge, don't clean their oven. It's a pain in the butt, but you got to do it or you'll be charged for it. You want to leave it completely empty. Don't leave a bag of garbage in there. Don't leave a bed in there. You know, you're going to be charged for these things, potentially moving them, and if you want your security deposit back, you've got to leave it empty and clean. Then once you move out, you want to send your landlord a letter asking for the deposit back. Give them a forwarding address of where they can send your security deposit. Keep a copy of that letter. And then if they don't return your return your deposit in a fair amount of time, let's say 30 to 45 days, you can seek to sue them in court. And if you haven't paid your rent, or if you've damaged the property in excess of what the security deposit was, they can countersue you. So you got to be aware of that.
Quick question.
Sure.
We always wait a month after they move out before sending the money back, just to make sure all liabilities are cleared for that month. Is that fair?
Yeah. That's about the usual time frame. The question was the timing of the return of the security deposit. You know, 1 to 2 months is usually a very, very normal and fair time frame. So there are added protections for victims of domestic violence and sexual assault victims. The Illinois Safe Homes Act allows the tenant to insist that the locks are changed if they fall into this category, and also to leave early, to terminate the lease on 3 days' notice if they're a victim. There's another act that provides additional protections for people in federally subsidized housing. If you're dealing with those issues, you should call Prairie State. So eviction is, we deal with, of those 381 cases that we closed last year, probably 350 of them were evictions. So the procedure is very simple, but it needs to be followed, and some landlords just don't follow it. Most at this point in McLean County do. So you have to serve the tenant with an eviction notice properly. So what that means is you hand it to them, mail it certified mail and get the certified letter back, or have someone else hand it to them, hand it to someone over the age of, I think, 13 that lives in the apartment. You know, that's not an exhaustive list, but those are the most common ways that you should do it. If you don't do that, then the case could be dismissed because of a failure to provide a proper eviction notice in the proper way. After the notice has been tendered to the tenant, usually it's a 5-day notice for non-payment of rent, or a 10-day notice that they did something wrong, or a 30-day notice ending a month-to-month tenancy. The landlord, after those days have passed, if the person doesn't pay their rent in the 5 days, for example, the landlord can file their eviction case at the courthouse. They'll have to hire a service processor server. The sheriff or the process server will serve the tenant and say, you've got a court date in such and such a date. That's what the document says. The tenant should attend the court date. Only a judge can evict a person. This is a common misconception we deal with. Usually once the eviction process starts, the landlords are hesitant to accept rent because that could open them up to defenses to the eviction. So they'll say, we're not accepting it. Someone will hand them rent, they'll give it back to them. You still owe the rent if you've lived there as a tenant. Even though the landlords refused it, you still owe the rent. If you win at trial, let's say there's a failure to serve the notice properly, or they're evicting you for being too loud and you weren't too loud, or the landlord fails to prove their case, you still have to turn around and pay all the money for the months of rent you were in there and there was a dispute. Usually this process takes over a month, so these months of rent start racking up. And if you want to stay there, you need to be able to pay.
Can you talk about the consequences of asking for a trial date when you don't actually have a defense and you just want time to move?
Yeah, I guess, so the question is, what are the consequences of asking for a trial date if you don't have a defense and you're just looking for time? First and foremost, it doesn't necessarily buy you more time. The judges try and set these things very quickly. So they'll try and set it, and you may get less time. Just to give you guys a little context, Taylor interned with us for a semester, so she saw this procedure in sort of how the court system works. If you show up to this court date at the first return, so let's say all this stuff's happened to the date where I say the tenant should attend the court date. They attend the court date and they admit to the judge, I didn't pay my rent, can I have some time to move out? The judge will generally give the tenant 14 days to move out here in McLean County. It's different in every county. If the tenant asks for more, they might get more, but usually they'll get a minimum of 14 days, and that's usually what most people get. We get the question sometimes is, if I ask for a trial date, will it buy me more time?